Hello everyone, I'm Apoorva Pandita and welcome to Live Law. Today in this video, I'll talk about disqualification for membership of parliament and state legislatures. This disqualification is mainly dealt with under Representation of People's Act 1951. But before knowing the law, we must know as to why are the members of parliament or legislative assemblies disqualified in the first place. They may be disqualified under certain circumstances to ensure that the democratic process is fair and transparent and to maintain the integrity of the entire electoral system. Disqualifications can be triggered by various factors such as criminal convictions, bankruptcy, and conflict of interest. You should also know that there is a separate provision of disqualification for commission of corrupt practices. But today, I'll only cover the disqualification on conviction for certain offences. Such disqualifications are provided under Section 8 of the Representation of People's Act. Section 8 talks about various offences and how a person is disqualified. You must have heard about Section 153A of the Indian Penal Code. Section 153A is invoked for the offence of promoting enmity between different groups on the ground of religion, race, place of birth, residence, language, etc., and doing certain acts prejudicial to the maintenance of harmony. In other words, the so-called hate speech and certain activities of politicians promoting hate in the name of religion, race, or other parameters of difference will eventually mean an offence under this section. Now, because of Rahul Gandhi's disqualification, it is known to every person that if an MLA or MP is convicted and sentenced for 2 years, then that person can be disqualified. But in case of Section 153A, even if a person is convicted with just fine, like even if he is convicted with just ₹100 fine, then that person will be disqualified from the date of such conviction for a period of 6 years. Just like 153A, there are so many other grave offences attracting disqualification, like offence of bribery, impersonation in an election, rape, cruelty towards women, practicing untouchability, or being a member of unlawful associations, offences related to narcotic drugs, etc. Even an offence of insulting national flag or the Constitution of India can eventually lead to disqualification. Although I haven't mentioned all the offences so as not to complicate it further. There are more such offences mentioned under clauses 1 and 2 of Section 8. Now coming over to clause 3 of Section 8, as per this clause, a person shall be disqualified if the person is convicted and sentenced to a minimum of 2 years for any other offence under any of the statute. The thing that we need to note is that in any case, the period of disqualification will be 6 years. The only difference is that in cases where the convicted person is also imprisoned, then this period of 6 years shall be calculated from the date of his release. Let us understand this through an example. For example, X is convicted for an offence in 2010 and imprisoned for a period of 4 years. So in such a case, this person X shall be disqualified immediately after his conviction, that is in 2010. But he shall continue to be disqualified till 2020 because the period of 6 years shall begin from 2014, that is after his release. Now what happens after the person is disqualified? So after a person is disqualified, it can also be reversed, that is, the disqualification will not take place in cases where any higher court grants a stay on the conviction or decides the appeal in favor of the convicted member. When we discuss this reversal of disqualification, it becomes essential to understand the case of Lok Prahari versus Union of India. In this landmark case, the Supreme Court had clarified that the disqualification will stop operating as soon as the conviction is stayed by any appellate court. However, it is important to note that there must have been a stay of conviction. Merely a stay on sentence or suspension of sentence would not help the convicted member to reverse his disqualification. In simple words, if any appellate court grants bail to a convicted member, it would only mean a suspension of sentence as had happened in the recent case of Rahul Gandhi. Although he was granted bail, his conviction was not yet stayed, and therefore his disqualification could not be reversed solely on this basis. Another possibility can be that the convicted person is discharged of the offence by the appellate court. Obviously, in cases the convicted member is discharged of the higher court, the disqualification will be reversed and the status of MP or MLA shall be restored. Now we come to the question whether any safeguards are provided to a sitting member to stop the disqualification from taking place. Earlier, a safeguard was provided to the sitting members of Parliament or state legislatures in the form of Section 8, Clause 4. But calling it ultra vires the Constitution, it was eventually struck down in Lily Thomas versus Union of India in 2013. The same view was further upheld in Lok Prahari versus Union of India. Section 8, Clause 4 of Representation of People's Act, which is not operative now, stated that the disqualification will not take place immediately after the conviction. It could take place only after 3 months from the date of conviction, and within this period, the convicted person could file an appeal. And as per the earlier law, disqualification was paused if an appeal against the conviction was filed before the higher court. However, this clause was struck down in Lily Thomas' case. What about the present scenario then? Well, as of today, the MPs or MLAs do not have any safeguard against the disqualification proceedings, and only a stay of conviction granted by a higher court can reverse the disqualification and make that convicted person eligible to be an MP or MLA again. Well, that was all for today's video. I really hope that you like our content, and if you do, then do not forget to like and subscribe to our channel. And for more legal updates, keep watching Live Law.